This is an AZCourtHelp Legal Talk. Unarrested for DUI. Now what? Thank you.
My name is Shahin Damoui. I'm an attorney here with MayesTelles. I just kind of want to give a little bit of an overview of what you can expect going through the DUI process here in Arizona. A DUI, as most people are aware, is for the most part, I'd say about 80% of the time has to do with when obviously there's alcohol above the threshold in your system. So mainly we're talking about when people are obviously drinking and driving in above the threshold. If you're 21 and older, of a 0.08 is the threshold they're looking for here in Arizona. Now there's also DUI if there's any illegal drug in your system, even if that's a prescription drug that was prescribed to you, if it impairs your ability to drive. So ultimately, we're not just looking at alcohol, though that's mainly the what most people connect DUIs with. It can also be, again, with legally prescribed drugs to you if they're taken to a level where it has impaired your ability to drive. Penalties. So there's different levels of DUI here in Arizona. The base level, as most people are aware of, is once they have a blood alcohol concentration level of 0.08% or more, or 0.04 if you're in a commercial vehicle with a commercial license. What automatically happens when you're pulled over and they are suspecting you of DUI, what's going to occur is the officer has a standardized form that they have to read to you that's known as the implied consent form. Now that form, a lot of people, obviously, if they have had some alcohol, they may not be paying attention to these questions or some of these statements that the officer makes to you at that time, but they're very, very important for a couple reasons. So when you're pulled over and they suspect that you may have been drinking, the officer will first either perform some field sobriety tests to determine whether or not he believes there is a reasonable suspicion that you've been drinking. He may also ask whether or not you will consent to a breathalyzer. Now, you're not required to consent to a breathalyzer. You can opt for blood. However, if you refuse both, you're looking at an automatic 1-year driving suspension. And ultimately, a lot of people believe that that they don't have to consent to either, and they're right, they don't. But ultimately, the only thing that does is it may make the process 10 or 15 minutes longer, because then the officers just get a warrant and they take your blood anyway. So there's nothing to be gained by refusing, but only something to lose, being a 1-year automatic suspension. With the motor vehicle department, we'll go in a little bit more detail as to the differences between the penalties that come from the motor vehicle department and from the courts. So they're very separate and distinct, but they both are going to have consequences and penalties when you are convicted or charged with a DUI. So you're going to have things that the court's going to expect you to do, and you're also going to have things that the motor vehicle department's going to expect you to do. Now, when we talk about this 1-year suspension, if you refuse to consent, that has to do with the motor vehicle department. That's not with the court. So ultimately, if you do consent to breath or blood, you're looking at a 90-day suspension. If you do not consent, you're looking at a 1-year suspension. So it's going to benefit you in the long run to consent to the blood initially, because again, all that refusal does is it just requires them to get a warrant, which will maybe take 20 or 30 minutes, and then they're going to take it anyway. But then you will be subject to that 1-year automatic suspension with the motor vehicle department. So the court's going to expect you to do some things, and the motor vehicle department. And so, again, you don't want to confuse the two, and you want to make sure that you accomplish what you need with each. First-time offense DUI, they have what's known as statutory minimums, which what that means is no matter if you have the greatest lawyer in the world, they are minimum penalties that you will have to abide by. Again, there's no way around it. And those minimum penalties are going to be not less than 10 consecutive days in jail. And there are some options. There are some work release options, in-home detention options, but you will be expected to serve at least 20% of that in custody. So again, if we're talking the 10 days, 2 days would have to be in custody. A fine of not less than $1,250. There'll always be alcohol screenings, education, and treatment that come with that as well. And there'll also be mandatory interlock that you will have to put on a vehicle. Now, oftentimes we get asked, what if I no longer drive, or what if unfortunately, there's no way around that. So there has to be a vehicle that you put that interlock on, because that will be a requirement from the courts. So again, if there's a vehicle, in your household, whatever it may be, they need to see proof of an interlock on that device or on that vehicle for at least 1 year. And there will be community service that goes along with that too. So although we are talking to class 1 misdemeanor, the penalties, not only financially, but on some of the classes, counseling, treatment, interlock, it adds up. Again, not just financially, but it's a lot. So they are, really trying to incentivize people not to get DUIs, obviously. Now, when we talk extreme DUI, now we're looking at blood alcohol concentration level. So we're looking at our traditional DUI, we're looking at a 0.08 to a 0.15. Now, when we're in the extreme, we're looking at a 0.15 to a 0.2. So again, obviously an extreme meaning that you're more intoxicated than you are in the first level, in the one that we were previously speaking of, the 0.08 to 0.15. Now, when we talk about an extreme, they also have mandatory minimums. Now, with the mandatory minimum on an extreme is not less than 30 consecutive days in jail, a fine of not less than $2,500, and the same mandatory education, treatment, interlock device, and community service. So again, every level that you go up, you're not only going to be subjected to more fines, but also more jail time. Now we're looking at super extreme. Now, super extreme is going to be between or anything from a 0.20 and above. Now, a super extreme conviction is still a class 1 misdemeanor, as are the others, but now we're looking at 45 days of jail. Again, the minimum is a 90-day license suspension. And again, you just want to keep in mind that is separate from what we were speaking of earlier with the motor vehicle department suspension. And there are some nuances where if you are going to be sentenced to a 90-day suspension from the courts, you can essentially try to plan that to where you serve both 90-day suspensions from the courts and the motor vehicle department at the same time, so that it doesn't become 180 days. So there are ways to essentially combine some of these terms and conditions. But again, it's just very important to remember that you have things that you're going to owe. And by owe, I mean there are terms and conditions that you'll have to abide by that are strictly through the motor vehicle department and strictly through the court. So even though some may be redundant, you have to make sure that you're accomplishing what you need to on both ends, not just one. Now, again, this is just a chart that I thought would be helpful so that people can see just as you go up levels. And again, these are all first-time penalties when we talk about. So obviously the difference between your standard 0.08 to 0.15 or 149, you're looking at 10 days jail. Now when we jump up to the super, now we're up to 45 days. And obviously you can see as each level, the fines increase significantly as well. And so I think that chart gives kind of a good overview of what you'll be looking at. And again, these are minimums. So again, there's no way of curbing or not having to accomplish any of these terms and conditions. Now, aggravated DUI is a little bit different. So there are certain situations in which you may have a DUI, and it could be any level DUI. It could be your regular DUI. It could be your super extreme. It can be an extreme DUI. Now, there are certain things that can aggravate that regardless. And when we talk about aggravated DUI, the most common occurrence for an aggravated DUI is going to be when someone is getting repeated DUI. So when you get your fourth DUI within 7 years, and that sounds, like a lot, but you'd be surprised. A lot of people, obviously, if you're struggling with alcohol and stuff, it is not uncommon. And so your fourth one would not only be a felony, but it would be an aggravated DUI. So now we're completely out of misdemeanor land, and now we're into felony land. Another common reason to get an aggravated DUI is if You could be just at the regular level DUI 0.08 or above, and you have a child in your car. That's going to automatically take you to a aggravated DUI. And again, I can't stress enough, aggravated DUIs are much more severe than any super extreme. Again, now we're in a much more serious territory with aggravated DUIs. Now in Arizona too, any situation where you're driving on the wrong way of the road or on the wrong side of the road, that's going to take you to an aggravated DUI. DUI that causes serious injury or fatality can be an aggravated DUI, or it can even be a manslaughter charge. So again, the aggravated DUIs are going to have very, very harsh penalties to encourage curbing that kind of behavior. So again, you're going to see that mainly with if you have a first-time DUI and there's either a child in the car with you, or if you're driving on the wrong side of the road and you're under the influence, or if you're received, it's your fourth DUI within a 7-year period. And now as we're looking here on these penalties, looking at up to 2 years in jail. Again, the other ones we're looking at a matter of days. Now we're in years. So again, I can't stress enough, aggravated DUIs are very, very severe, and they're not to be taken lightly. Now we're going to talk a little bit about the administrative penalties, which is everything through the motor vehicle department. So again, as we spoke of, when you're pulled over, when you're arrested, you're automatically going to be subject to a 90-day suspension. And that's if you consent to breath or blood. Now, what you can do is you request what's known as an admin per se hearing through the motor vehicle department. And what that does is that stays any sort of suspension. So the suspension is temporarily paused. They'll give you a date at the motor vehicle department admin per se. They'll give you a time. You will have to go there. They'll also have the officer, the arresting officer will be required to appear. And at that time, if the officer doesn't appear, then that suspension is void. You don't have to worry about it. If the officer does show, they do not need to put on a whole lot of proof. Like I said, this is an administrative hearing, so it's not a criminal court. It's not a beyond a reasonable doubt standard. It's just a preponderance. So the officer, if he comes and he says, because of X, Y, and Z, I believe that they were under the influence, then the administrative law judge there will make a determination whether that 90-day suspension stays or whether it's voided. However, if you're looking at the potential 1 year, which we talked about, if you refuse to consent to breath or blood, same situation, you can ask for a hearing. That hearing, if the officer doesn't show, it'll be voided. If he does show, the officer only has to show that he read you this piece of paper known as the implied consent form, and that you refuse to give breath or blood. If he shows that, you're looking at a 1 year suspension automatically, no way around it. Which is why it's very important that when you are stopped, like I said, a lot of people are kind of given that information that you don't need to consent to either. And although that's accurate, people don't tell you what you may be facing on the administrative side. And again, you're not saving yourself any trouble really, because they're just going to get a warrant and get your blood anyway. So you definitely don't want to be subject to that 1 year suspension. But again, these are some of the administrative penalties that come aside from the criminal penalties through the courts. So again, you do have the right to challenge these. They will give you it's not a court date, but it's a hearing date with the motor vehicle department, in which if you believe, like I said, that anything was done unlawfully, wrongfully, whatever it may be, you have the opportunity to present your case. But again, it's very, very low burden for them to show, because again, we're not in court. They don't have to prove it beyond a reasonable doubt. So it's a very difficult hearing to overcome unless the officer doesn't show, in which case they'll be forced to void that suspension. And we kind of alluded to it a little bit earlier, but there may be some situations where, as part of your sentence through a criminal court, they may have a term of suspension that they want on your license. And what you can do is you can essentially coordinate that suspension to occur at the same time as either that 90-day suspension through the motor vehicle department or that potential 1 year suspension, so that you're not serving suspensions at different times through the court and through the motor vehicle department. And now, again, obviously with any sort of moving violation, you're also going to get points on your record. And so again, when you look here on the right, All the DUIs are going to be a standard 8 points. And again, with 8 points, 8 or more points, you are looking or subject to that suspension absent the traffic survival school, which again, when we talked about the requirements for, some of the mandatory minimums that come with every DUI conviction, that traffic survival school is going to be one of those classes that they require you to take as well. So that's due to the fact that you will have 8 points put on your record, which will subject you to an automatic suspension. So again, a little bit, a lot of things to kind of keep in mind, but it's just important. If we had to summarize it to 3 big points, ultimately consent to breath or blood initially, because it's going to save you a lot of potential suspension time, or it's going to make your life a bit easier. And again, there's no benefit to refusing. So I've also keep in mind the financial costs that come with every single DUI, even your first offense minimum DUI, fines, fees, everything included, especially if you're also retaining an attorney. You're conservatively looking at, 7,000 or 8,000 out the door. Any level you go up, it's going up significantly higher. And especially when we get into the aggravated DUIs, I think the biggest takeaway is to be very, very mindful of those situations. Because if you are charged with a felony, if you have a situation where you're not really thinking, you have a minor in your car or whatever it may be, those aggravated DUIs are really going to have a lasting impression or a lasting impact on your record, much more than any sort of other DUI. And it will be a uphill battle from there, especially like I said, because those are treated as felonies and much more serious offenses. Now, there is, I don't want to say good news, but ultimately, if you've had a DUI, you've done everything you need to, you've completed your sentence, your terms and conditions, you've done what you needed to. There is some encouraging, information, some encouraging things that can happen after that fact. There's what's known as a set aside, which has always kind of been Arizona's default when it comes to any sort of post-conviction relief. Arizona never allowed for expungement. So set aside was really as good as you were going to get when it comes to options after the fact. However, Arizona has enacted this sealing law. Now, the sealing law really hinges on all the terms and conditions of your sentence being completed. So, for example, if you were convicted of a regular DUI as a class 1 misdemeanor, all those fines and fees that we talked about, those classes and courses and education that you have to do, once all that is completed, then you have to wait 3 years once all that is completed. If you wait 3 years and in that 3-year period, you have no new convictions, then you can apply to have your record sealed. And if that's granted, then it will be shielded from public view, meaning, your creditors, your landlord, your job, nobody will be able to actually see it. It won't show up on a background check, so it's sealed from view. And it goes even further and states that if you are granted that sealing, that when you're asked on either an employment application, any sort of application, when they ask you, that dreaded question, have you been arrested, convicted? You can answer in good faith, no, I have not been. And it will not show up. So those are just some of the things that some of the options you may have once this is kind of all done with and you've completed all the terms and conditions of your sentence. And again, the amount of time you have to wait comes down to the level of offense that it is. So for the regular DUIs that are class 1 misdemeanors, it's a 3-year waiting period. As you bump up into aggravated DUIs, if we get into felonies, those are going to be much longer waiting periods, anywhere from 4 to up to 10 years on some, if it's a really serious felony conviction, that they will make you wait before you can apply. But for all your regular DUIs, it's going to be a 3-year period. So then, like I said, it gives you an incentive to complete what you need to complete, get it done, over with. Because like I said, if you get that sealing granted, it's almost as good as an expungement, because again, for all intents and purposes, no one will be able to really see that moving forward.
Thank you.